when a jury trial starts, there's a thing called voir. And that's where the attorneys can ask questions and decide which jurors get to stay and which ones go. Depending on the size of the trial and the length of the trial, like a murder trial, you may get more peremptory challenges. Peremptory challenges where an attorney can excuse somebody from the jury pool without really a reason. One thing they can't do is excuse somebody because of race, gender, religious beliefs, national origin, age, sexual orientation, and so forth. So you can't excuse people just because they're African American or they're gay or they're Jewish. But you have to have a reason, like she doesn't like cops. Naja hates police officers. So as a prosecutor, I would kick her off. Because I'd ask her, do you have a problem with police? She goes, well, yeah, they're horrible. And so Suzanne's arrived. So we're ready to go. So I can say, well, she has a bias against police, and then I can excuse her. Now, typically, in most cases, you get 3 peremptory challenges. Is that correct? 3? John says yes. But on large cases, a trial that's going to last several weeks, maybe months, you can have a lot more. It's, under Rule 11, it's total discretion of the judge and the court on how many peremptory challenges you get. But typically, it's 3. I had a murder case in Pueblo where Judge Reyes gave everybody 3 peremptory challenges and told them they had to select a jury for a murder trial in 2 hours. They had 2 hours for voir. And it was a horrible case where they murdered this girl and left her on railroad tracks so her body would be cut. She was already dead, but they wanted her body to be destroyed by a train after they murdered her, these 2 guys. And he said we had 2 hours to pick a jury for that. So it's up to the judge. There's really not much you can do about it. But anyways, so the first 6 here were the first 6 that walked in. You are the presumed jurors. So in any court case, the first 12 jurors that come in, that's the presumptive jurors. And they're all presumed to be eligible to sit on a jury. They have to be over the age of 18, not convicted of any felonies, and a citizen of the United States. Those are the requirements. And able to read and write with some certainty and speak the English language. So those are the requirements. Other than that, everybody's presumed. Now after, they'll bring in more jurors than 12 or 6. They'll bring them in because as they get kicked off the jurors, then they backfill them with other jurors or alternate jurors coming up. Long trials, they'll pick maybe 14 or 16 jurors. So that a trial that lasts several months, like Andrew Holmes, the shooter up there at the Aurora movie theater, they had 16 jurors in there. They had 12 presumptive jurors or 12 jurors that made up the jury, and then they had 4 others as alternates because the trial started in February and didn't end until August. So during that whole time, people can get sick, an emergency can come up at home, somebody has to go to the hospital, and they'll take those alternate jurors and fill them in. Now, an alternate juror will sit during the entire trial, take notes just like every other juror. They just don't get to vote. They don't get to go in the jury room and vote unless somebody is excused. People get kicked off of juries during trials because they do other things. I had a case where a police officer was charged with domestic violence. And one of the things they do with victims, the victim never filed a complaint. She had told her girlfriend that she supposedly got beat up, or allegedly got beat up by her cop boyfriend, and they charged him just based on that. When detectives interviewed her, she denied everything. Long story short, so the prosecution wanted to bring in an expert witness on domestic violence, testifying why women don't testify against their boyfriends, right? And so we had a counter expert to come in and testify that he interviewed the victim and she was not a victim of domestic violence. And he was a doctor of psychiatry. So anyways, long story short, it was a 3-day trial already. Prosecution put on all their witnesses. They arrested in their case in chief, and it was the defense turn. Now during the jury selection process, they give all the jurors a list of the witnesses and the cops and the DAs and everything. Says, do you know anybody on this list? And if you are, then you can be excused. The judge will excuse you for cause. In this case, my expert comes in. He's about to sit down. He stops at my table to testify, my psychiatrist. He points to a juror and he goes, I'm suing that guy. He remodeled my basement and screwed it up. And we're right now in litigation. So I had to talked to the judge in chambers, and it was Acker. And John will know Acker, he has a little bit of a temper. I actually thought the judge was going to stroke on this juror, but he didn't. I mean, his face was so red and his fists were balled up because we'd already been in trial for 3 days. And this was our 3rd day. And I thought he was just going to stroke out. He was so mad. I was going to step in between and catch the punch to save the judge. But we got a mistrial, and that was the end of that. But so they would have, a lot of times they would have just excused the juror. If we had an alternate, it was a misdemeanor case, so there were no alternates, so there was no one to backfill. So it was 3 days in court that were just totally wasted. So that's kind of the process. But this process for Dyer, these are graduate students. They're all getting their master's degree in criminal justice, and this class is called the American Jury System. And so part of their grade is they're going to do a voir dire. So they are going to talk to all of you and see which one of you are potential candidates to either stay on the jury or get kicked off. One will represent the prosecution, one will represent the defense. Everybody's being judged on their presentation. So they need a live body to ask questions. All I ask is that you answer them truthfully. Okay? You have 10 minutes.
Hello and good evening. My name is Erica Welliver, and I am proud to serve the people of Colorado. In this case, and I have 6 of you decide this very important case. In this part of the trial, I need to find out your feelings, impressions, and attitudes, and or opinions about this case. Do you all understand? Good. We will begin. First question. Does anyone here, because of the nature of their employment, feel that they cannot judge this case impartially? This is all of you. No? Okay. This is all to you again. If you're selected as a juror, do you pledge that you will base your decision on the facts as presented in this trial and not on any past experience or prior opinions you might have about the subject matter of this case? All of you again. Who here has been a victim of a crime? Nobody? Okay. Have any of you had a family member that was a victim of a crime? Juror number 6. What type of crime was that?
My brother's roommate, he was on meth, and then he robbed my brother and then tried to kill him, and then my brother had to lock himself in the room with his gun and call the police and wait for him.
Was the defendant prosecuted?
They sent him to jail, and then after that, I really don't know.
Juror number 4. I see that you have a son. Is that correct? Yes. If somebody was entering your house, is there anything you would not do to protect your son? No. Juror number 3. I see here that you rent. Is that correct?
Yes.
Do you live by yourself?
Yes.
If somebody were to enter your house, do you think you'd be able to recall what that person looks like?
No.
Why is that?
I'd be more, I don't know, I'm just trying to figure out why a person's in my house in the first place. I would be overcome with like fear, I guess, more than anything. So.
Juror number 1. I see here you live with your family. Is that correct? I also see that you have a dog. Does your dog have a doggy door? No. Okay. Good. This is for all of you again. Do you think that in the criminal justice system, too many people are let off on technicalities? Or do you think that the system does reasonably well given the volume of cases? Do you understand that? Okay, we'll just go with the first part. Do you think that in the criminal justice system, too many people are let off on technicalities? Juror number 5, you shook your head no. Why is that?
Well, probably just because I don't keep up enough to like pay attention like that, but I've followed very many cases, so I've just seen that happen.
Okay. Juror number 6, you shook your head yes, right? Why is that?
Well, let's see. For instance, looking at the Casey Anthony case and how it was handled and the issues that were brought up. I wasn't personally there, so I can't really know all the facts, but believably, I would be reasonable to say that she did actually do it.
Okay. Juror number 2, why do you think most people commit crimes?
Because I think they think they can get away with it.
Why do you think they can get away with it?
Just the mindset they're in, whether it's has to do with drugs or I just think they have the potential to overcome the crime without being punished.
Juror number 5, why do you think most people commit crimes?
I feel like it's like a complex question. I think like there's instances where people feel like they have to do it, like if they're like stealing for their family or something like that. But I feel like it's also the same, like a lot of people think they're smarter than law enforcement and they think they can get away with it. So I feel like there's multiple perspectives of why.
Juror number 2, do you understand that evidence comes in 2 forms, direct and circumstantial?
Yes.
Do you believe that there needs to be physical evidence to convict someone?
Yes.
In all cases.
Physical evidence. And what does all physical evidence entail?
But, so if I tell you that my dog ate that shoe, I just tell you that, right? But then I show you that the dog ate the shoe. That's physical evidence. I physically showed you something that the dog had done, but just telling you that's circumstantial.
Yes, I think you can.
Okay. Juror number 6. Do you understand that there's 2 different forms of evidence?
Yeah.
Do you believe that there needs to be physical evidence to convict someone?
It definitely helps to have it, to prove without a doubt, but witness statements, would you consider that as physical evidence?
No, I would not. No, I would not.
Then I would believe that it's definitely necessary, or definitely helpful, but not always necessary.
Okay, thank you. Juror number 1, same question. Do you understand that evidence comes in 2 forms?
Yes.
Do you believe that physical evidence needs to be presented to convict someone?
Kind of the same, but it helps a lot, but I don't think it's always necessary.
Thank you. 2 minutes? Oh. Okay. Juror number 4. Can't count today. Would you believe that the defendant was hiding something if he or she did not take the stand?
No, not necessarily. They have the right to not defend themselves if they don't want to.
Juror number 3. Same question. Would you believe the defendant was hiding something if he didn't take the stand? He or she?
Yes,
Why?
because that is your opportunity to defend yourself. So it's like if you had nothing to hide, then it should be a problem for you to stand.
Juror number 6. Same question. Would you believe the defendant was hiding something if he or she did not take the stand?
I would say yes. They may be afraid of possible cross-examination, but based on that, I know nothing, so I wouldn't draw any conclusions.
So you're saying yes? That they would.
I would perceive him as hiding something, but I would not draw a conclusion from that.
Ladies and gentlemen of the jury, my name is Rich Radebaugh, and I'm defending Mr. Smith today on the charge of burglary. And so I'll be talking to you and asking you questions just to see what your opinions are. First of all, who doesn't want to be here today? Does everyone want to sit on this jury? Is everyone interested? No one doesn't want to be here? That's excellent. I appreciate that. How many people in here have been accused of doing something they were innocent of? How many? Have you, Ms. Hollins? Never? Did that hurt your feelings? If your teacher accused you of cheating on a test and you didn't? How would you feel?
Horrible.
Horrible?
Yeah.
How about you, Ms. Cron?
I would feel, I would have anxiety over something I didn't do.
Okay, has that ever happened to you? You've been accused of something you didn't do? Your parents, your brother said you stole something from him, went in his room, rifled his stuff? Anything like that?
Not that I can recall.
Ms. Nix, are the police always right? What do you think? Just be honest.
Well, personally, I think yes.
They're always right. They would never arrest
Okay,
anybody.
majority
that
of
is-
the time they're right.
But is there times they can make a mistake?
Sometimes,
Okay.
not a lot of the time though.
What do you think about that, Ms. David?
I think everybody has room for error.
And so they can always be
Mistakes are
made.
made, yeah.
Ms. Allen, what kind of evidence would you like to see? Do you like the idea that there might be fingerprints left behind?
That always helps.
And photographs?
Photographs, like of the.
Yeah, like a surveillance picture or maybe some video.
I mean, yeah, that always helps to make it more concrete, I guess.
Okay, but would you be able to convict somebody without any evidence like that?
I would say no. Or at least like if there's like no witness or anything like that, like no, I don't.
So even a witness, can a witness be wrong?
Yeah. So.
Can
I
a
would
witness be
really
wrong
just,
a
like,
lot?
I would say it really depends, like on the circumstance. But I mean, there's been like a lot of error in eyewitness testimonies.
Well, there you go. And Mr. Charbonneau, she said circumstance. Take a look at me. Under the circumstances, do you think I like donuts? Hi, do you?
Knowing your previous record of being a cop, I could.
But you don't know for sure. I might like ice cream better, right?
I don't know that.
I might like to hit, but you don't know.
I don't.
You can make an assumption, but it's not based on any fact, right?
That's
Is
right.
that correct? And you can see that with me. I like to eat, right? Actually, I have a glandular problem. That's why I'm big. No, I'm just- But what I'm saying is that Mr. Charbonneau says that circumstances can be misread. True?
Yes.
Now let me ask a question. In fact, Ms. David, you're pretty observant. I've noticed that when you're sitting here. Can you tell the difference between someone that's 6'6" and 6 foot?
Absolutely.
And if you only saw them for a few seconds, would you remember that?
The height difference?
Mm-hmm.
Yeah.
6'6" is really tall. I mean, we're talking the height of a door, right? Ms. Hollins, if you saw somebody and it was a crisis situation and they're wearing a baseball hat and it had so much glitter on the front that it looked like a chandelier, would you remember that?
Probably.
Probably?
I think so. It's like a lot of glitter.
I mean, just like it blinds you. It looks like a disco ball.
Yeah.
You would remember that.
Yeah.
Okay. Have you ever been in a crisis situation and forgot something? And what was that?
I was in a car accident,
Uh-huh.
and I couldn't remember the exact moment when I got hit. I just remembered like afterwards when I came up to my car. So I don't know where I was hit to be exact.
So you lost some of your memory there?
Yes.
And could some of your perceptions or what you thought happened be wrong?
Yes.
Okay. Now, based on that, you've been charged with a crime. How would you like it if that is the information they have? That they only have an eyewitness that points you out? Would you feel comfortable going to trial like that?
No.
Would you like that, to be in that situation?
No.
How about you, Ms. Cronger?
I would not like to be in that situation.
Okay. When you get seated as jurors and you get sit down, you're going to take an oath to uphold the law. And the law says that the client doesn't have to testify. The defendant doesn't have to get out there and defend himself. The burden rests entirely on the prosecution. They are the only ones that have to prove anything. My client doesn't have to say a word. Do you agree with that? You feel strongly about that?
I wouldn't say strongly,
So tell me, your dad's a policeman, isn't
he used to be, yeah.
he? Does that cloud your judgment?
I don't think so, no.
Did your dad ever tell you about stuff they did that was a mistake when they were cops?
No.
You know, everything they did was right.
I mean, he just doesn't really talk about it.
Okay.
Yeah.
Ms. Kronk, your cousin's a police officer, isn't he? Did you talk to him?
Not a lot, no. He's in Buckland, so
So you don't see him very much?
no, just that family get together, so once a year.
Do you think police officers ever make a mistake?
Occasionally.
Okay. And that's why we have trials, isn't it? That's why you guys are sitting here, is because police officers, the court system, witnesses, all of them can be flawed. And you guys get to decide what the facts are in this case. You understand that? Does anyone have a problem with that? Would anybody be strong enough? Matthew, are you strong enough if everybody else says that he's guilty and you feel in your heart he's not, that the state failed to prove their case, are you strong enough to stand up to everybody else and say he's not guilty?
Well, I'm a natural born leader, so yeah.
So there's our foreman, huh? Okay, well, thank you. I appreciate you coming in today. I really appreciate you taking your time to sit on this jury. We're going to present a case, and we're going to be opening here, and the judges have a few comments to make to you when we get done. But thank you very much. Okay, so who do you kick? Who's going off the jury?
Number 2, number 5.
Okay, so why? Naja and Shelby.
So Shelby is gone. Dang it, why? She's more on your side. She would definitely believe that Mr. Smith did not commit the crime. And this is not a very good reason, but Naja, you're very undecisive. So I feel like you're gonna sway whichever way is like the most. So if they say yes, like 4 of them say yes, and Matthew's over here saying no, you're gonna go with the 4.
How did you guys feel?
Again.
Felt good?
Comfortable.
Yeah. Did you like the defendant after I got done?
I didn't know.
But not yet. But did it kind of shake your mind that he could be innocent?
Yes.
Okay.
Wait, who would you have kicked off?
Oh, policewoman, daughter of one.
I would have her.
Shelby was kind of removed from her cousin. And probably Cassie, because she's pretty conservative.
No, those are my people. Those are my people.
If I was a defense attorney.
I know.
Okay,
That's
but-
they were my.
Like I said, I'm not being graded, so we're okay. All right, thank you. If you'll move to the back, we're going to switch you guys out.
My name is Kelly. I'm representing the prosecution for this case. I want to know your opinion about this case regarding Mr. Williams. So, does anyone feel like they cannot be an impartial juror? No. Okay, you guys can raise your hands if you think. Has anyone been a victim of a crime? What crime?
I was stopped and threatened.
Okay, and what was your crime?
Hit and run with my car. I tried to
Okay. Has anyone been a victim of a burglary? What was yours?
Someone broke into my house last year and stole our TV, and then they stole the car too.
Did you call the police?
Yes.
Were they prosecuted?
No, the police didn't come to my house.
Does anyone live alone? No? Okay. how accurately can you estimate height on someone? What's picture number 2?
I think that I would be pretty good at estimating.
Okay. What about juror number 4?
Yeah, like, I think so.
Okay. So what would, juror number 5, what would you think that evidence is?
Evidence is anything found at the scene of the crime that could connect the person to the crime.
Okay, so physical evidence, would you think that circumstantial evidence is the same?
Could you define that?
So what if you said that someone stole your TV, for example, and you didn't have really a picture of it, but you had witnesses? Would you still consider that as evidence?
Yeah.
The witness's testimony? Okay. What about you, juror number 1? So what would you consider evidence?
I would say anything that can like convict someone of a crime.
Okay, so either photos or testimony of someone else? Okay. So juror number 4, do you have a problem with police?
No.
Okay, what about you, juror number 3?
I do not.
Okay. Would you recognize someone after startling event, juror number 2?
I would hope that I would. I think it would depend on the circumstances exactly.
Okay. So juror number 5, what if someone broke into your house or your car and you saw them running away? Could you estimate their height and weight and all of their characteristics accurately, or would you be too startled?
I don't think it has to do with me being startled. I would just be I wouldn't be able to judge that anyways because of like muscle mass. I can't tell like how big a person is and how much they weigh.
Okay. So juror number 3, what is reasonable doubt to you?
To me, reasonable doubt is anything, whether it's a piece of evidence or a spoken word, that implies that someone might not have committed a crime.
Okay. What about you, juror number 6? What is reasonable doubt?
I would have to agree with her. Anything that could prove any doubt about who committed a crime.
Okay. What about you, juror number 1? Do you believe that I could prove to you beyond reasonable doubt that the defendant is guilty of the charges that are laid here?
Depends on how much evidence you have.
If I had circumstantial evidence and not photographs, would you still believe it? Okay. So, what if juror number 4, what if there was no DNA evidence in this crime, but there was an eyewitness? Would you still be able to believe that, or would you need something more?
Like, I believe that they saw everything. Probably believe them.
So does anyone believe that you have to have DNA to commit a crime, like leave DNA at a scene that you committed the crime at, to actually have that there to put that person at the scene? Or can you just have some testimony?
I think testimony and circumstantial evidence, I think all evidence besides physical evidence can prove beyond reasonable doubt that a person is guilty. But I think that physical evidence really proves that this person is guilty.
Okay. And that's all my questions.
Good evening, my name is Diana Borges, and I'm going to be the defense attorney for this burglary case. I'm going to ask you a series of questions, so please try to answer them as honestly as possible, okay? Okay. Ms. Robinson? Okay, you said you work at a bank, is that correct? Okay, was there ever a time when there was maybe a bank robbery with your bank and you had to, like, you were witness to that and you had to, nothing at all? Okay, you say you're very observant as far as people are coming to the bank. So you observe this around all the time? Thank you very much. Ms. Crawford? Hi, how are you?
Good, how are you?
I see you are a pre-law student, is that correct?
Yes, ma'am.
Okay, and you are also a member of the pre-law club?
Yeah.
Okay, and what kind of things do you guys like talk about and do? I know it's law related, but you know.
Yeah, we prep for like LSAT, and we talk with people who have already taken the LSAT. We also suggest courses that are best for law school preparation and lots of those stuff.
Okay, thank you. I'm also, is it true that you know someone who was a victim of a homicide? Is that correct?
Yeah,
Okay, and what was that relationship to you?
it was just a friend from high school.
Okay, and so do you think that you could be fair and impartial juror on this case?
Yes, I do. I wasn't that close to the murder victim, but I do know, so I didn't want to leave that out.
Okay. Do you think that you are a good judgment of someone's height?
Yes, ma'am. I would say.
Even if you're like, say, if you're not like on the same level as them, or say you're higher up, or you're looking down,
Yeah.
you're able to think that you can, you know, identify them later if you had to?
Yeah.
By the height?
I'm pretty like height conscious because I'm tall myself, so like I'm like checking out people's heights if they're short or tall.
Okay. Did anybody here ever had to write a police statement for anything? You have, okay. And was that for
It was a hit and run.
a hit and run car accident? Okay, exactly. Would you say that maybe a day after that accident, did you think about the statement that you wrote and thought about you may have left some things out?
I actually felt very confident in my statement.
Okay. I have some questions for everybody here. Do all of you feel that a defendant in the case should take the witness stand? You don't feel that way. Why not?
Because oftentimes they're like legally advised by their lawyer to not do so. And one of my friends was he killed someone. I don't talk to him anymore, obviously.
Okay.
But he didn't take the stand, and that was because his lawyer advised him not to, because it would sway the jury one way or another. Like, doesn't matter what he said.
Thank you. And so everybody else here thinks that the defendant should take the witness stand?
I think same as her, the defendant, if he's advised not to take the jury stand, if he wants to, try to hold on to his innocence as long as he can, or she.
So then you basically feel that that would really hurt the case, regardless. What about you, jury number 3?
Yes, I feel that they have the right to take the stand if they so wish to, but either way, it does not affect my opinion or my thoughts on whether or not they're committing a crime. It just, they have that option to or not to.
Okay. What about you, jury number 6?
I mean, they have the right to do whatever they want, but I think that they should, because why wouldn't you want the chance to prove that you're innocent?
Jury number 4, what do you think?
Oh, basically the same thing. You did have the chance to speak up.
Ms. Jenkins? Already? Jeez, okay. Let's see, you said that you also know someone that has been a victim of crime, is that correct? Okay, and how close were you to that person?
Very close.
Very close to that person. And has that really affected you a lot? Do you think you could be fair and impartial on this case?
Yes.
So you think it would bother you? Ms. Wolfer?
Yes.
Sorry. Also, you know someone as a victim of crime, is that correct?
Mm-hmm.
Okay, and how does that affect you?
It has not affected me all too much, honestly. I know them, but it hasn't really part of my life.
One other question. Everybody's familiar with doggy doors, correct? Okay. Do any of you here believe that a grown person can fit through a doggy door? Size? Okay.
Number 6,
Chelsea?
because of her statement to defense, about the defendant taking the stand.
Does it help that she interned for a defense attorney?
No.
Who else?
Maybe number 5, because of, I don't remember.
Okay. Well, I said it could just be a gut feel. You could just say, yeah, that person just kind of grates.
I really like 2 and 3 though. Like, they're totally on my side.
How about you, Diane? Who's prosecuted already?
I think, Ms. Burnett, is that you?
I'm Robinson.
Robinson.
Burnett, okay. I thought it was a police officer. Kind of like, so that could be a little, you know.
Yeah, but she could hate her dad.
No. And, let's see what I had here.
Okay, so you're gonna pick one if you think one is bad?
I just kind of think that, yeah.
Mariah, how do you feel? Do you feel still neutral?
Yeah.
Okay, and you can be impartial?
Yeah.
How about you, Haley? What do you think?
I'm neutral.
You ready to serve on a jury? Drop the hammer on somebody? How about you, Ann Melissa?
I also feel neutral about it.
Anybody else that doesn't feel neutral?
I mean, despite the fact that you cut us, I think we're still here.
Okay, well, excellent job. All right, thanks.
All right, good evening, ladies and gentlemen. My name is Susanna Lazada, and I am here on behalf of the people of El Paso County, Colorado, to seek justice. It is my job, after the police have gathered all the evidence in the case, to take the evidence to court to present to the jury, such as you guys. Right now, we are going through the process called voir dire. Voir dire is a French term which means to see and to speak. This will be my only opportunity to speak to all of you one-on-one to elicit your response to some questions to determine whether or not this type of case that you can consist as fair and impartial jurors. We're looking for complete honesty and openness. If you feel a certain way, that's okay. We just want to know whatever you feel. So that is what we are looking for. The people who can just decide the case based on information and evidence elicited in this court. Do you guys feel you can do that?
Absolutely.
Wonderful. So off to my questions. Is there anyone here who has been a victim of a crime? Can you explain to me what crime?
I got partially stabbed from a bar fight.
Oh my. So I'm guessing the police was called.
Yeah.
How did you feel? The police did a good job. Didn't you have any animosity with the police officer or anything? Okay. Thank you. Were you traumatized due to the incident? No. Okay. I'm sorry, guys. Okay, now I believe it is important we use common sense when we judge evidence, correct? You guys, okay. Would each of you agree with me and promise me that you will use your common sense and reason when evaluating evidence that is given to you in this court? So following this question, Megan.
Yes.
Would you agree with me that it is common sense that if a defendant went inside a doggy door, per se, that there's intent behind it and he's not just going inside to just look at the furniture?
Yes.
There's intent that he wants to commit some kind of crime, correct? Okay. But, I don't know, would you believe that as well?
Not necessarily, depending on the circumstance. I would say maybe he's trying to defend himself from someone. Depending on the circumstances, I would not necessarily incriminate someone for a crime for it, but there's definitely something special about that situation for a person to go through a doggy door.
So that defendant was probably threatened and he went through the doggy door to protect himself?
Possibly.
For sure. Okay, thank you. So who likes to watch TV, crime TVs,
CSI and all that. Alrighty. Who agrees with me that those shows are for entertainment and not real? Okay. Would you have to see fingerprints, DNA to believe that someone is guilty? Would you believe that, Chelsea?
It would definitely help.
Definitely help. Alright. So part of my job is to prove that the defendant is guilty beyond a reasonable doubt. So, Casey, do you understand or think you understand what is meant by reasonable doubt?
Yes, I do.
That it's something from your heart of hearts, and if you are convinced that in the end of the evidence that you believe the truth of the matter is asserted to you, that you are convinced beyond a reasonable doubt. Does everyone agree with that? Okay. So how can you guys, for example, I want to ask you, Matthew? Okay. How can you tell someone is lying based on somebody's telling the truth? What do you look for?
Micro expressions, signs of guilt, if they're sweating, using a lot, it just.
Their demeanor, right?
Yeah, the
right.
demeanor.
All right, thank you, Matthew. So there are different types of evidence presented in a criminal case. There's what we call direct evidence. Direct evidence, for example, if you see somebody going through a dormitory and you, Chelsea, you see that happening, that's direct evidence, you're seeing this happening. And there is circumstantial evidence, like for example, snow is coming down, then you get up, you open the door and you see footprints, and what would you assume that is? That somebody is going from the house to the car, if you see footprints to the car, correct? So, which would you believe is more important, like more of a, more stronger evidence? Circumstantial or direct evidence? Direct?
I would consider both equally, depending again on the situation, I would consider them equally important.
Equally important? All right, thank you. Okay. Would you guys believe that somebody, they feel, let's see, one second. If somebody goes through an incident of a crime and is traumatized, do you believe, like during that incident, a person can recall everything that's happening? Do you understand my question?
I do, depending on the person, depending on the circumstances, and depending on how traumatized and how involved he is. Certainly not everything, especially if it's a high-space situation, when a lot of events happen very fast, especially if he's involved in the situation, that would be greatly affected. But not necessarily. There are people that can recall everything, even in high-stress situations. So it's very
Wonderful. What about you, Megan? Would you believe that if you're traumatized in an incident, like a case, a criminal, like you're in a criminal, you're in a case where you're being burglarized and you see something happening fast, do you think you can recall that incident, or how that person looked, what he was wearing, or do you think that you can recall all that information? Right. Would that make you less credible though?
Yes.
Less credible
Because the more often you try to remember something, the less accurate it is. So
Okay. Thank you. Well, thank you guys for your time.
Good evening, ladies and gentlemen. My name is Kevin Collett, and I'm proud to stand here with my defendant, Dan Williams, and have you decide this very important case. But in order to do so, in this part of the trial, we need to find out your feelings, impressions, and opinions about issues in this case. A case that very much rests on your thoughts and opinions regarding certain aspects of the law and perhaps how Mr. Williams was mistakenly identified. All of us, myself included, have feelings and thoughts that lead us to prejudgment. I would not be a fair juror in every case, and that's okay. We would not be human if we didn't possess these qualities. Therefore, it's better for you to say what's on your mind here and now, and let me know if anything bothers you, okay? So let's get started. Megan, you mentioned to the prosecution that less credible eyewitness would lead you to believe that maybe that's not very good evidence. Is that correct?
Yes.
Is that what you said? So, let me ask you, what type of evidence would you like to see in a criminal case in order for you to think that someone's guilty?
Hard evidence like DNA or something like that.
Perhaps witness video, or multiple witnesses, video, fingerprints, that sort of thing?
Yeah.
How do you feel about that?
I would like to see hard evidence, such as DNA, video, footprints.
Right. So, could you say that you also agree that maybe witness testimony isn't the best type of testimony?
Like the witness who actually saw the crime?
Yes.
I'd say witness testimony helps out. It's not necessarily direct, but if somebody were to actually see the crime, the testimony definitely helps out.
Okay. Now, did I understand you were stabbed? Is that what I understood from the sidelines? Holy moly. So let me ask you this. Were you able to well, let me ask you this first. Did you know the person you stabbed?
No.
Okay, so how well in this high-tense situation were you able to recall what your perpetrator looked like?
Pretty much everything.
Yeah?
He fell into me, so I couldn't remember his face.
Okay.
And so that's how I got partially stabbed. He fell into me trying to stab me.
Were you able to describe that to the police?
Yes.
Okay. Did they ever find you?
Yes.
Okay, thanks. How about you? What are your thoughts on witness testimony?
It's a good thing and it's a bad thing. If you can disprove their credibility, then I would sway more towards one side. But if there's no way of actually showing that they are accounting or recalling events that didn't happen, or without error, then I'd be more inclined to believe them. But it's all depends on how they actually perceive it and what evidence is brought up from their testimony.
So your jury questionnaire stated you had been a victim of a crime in the past, is that correct?
I'm trying to remember, but it probably wasn't that
So
memorable.
nothing serious?
Yeah, it wasn't really anything serious.
Has anyone else, other than being stabbed, holy moly, has anybody else been involved in a serious crime? A victim of a serious crime at all? What about any stressful situation? Not necessarily a victim of a crime, just a super serious, stressful situation?
All the time.
Yeah. So, did any of you in that stressful situation think you could recall exactly what happened moments after that occurred to you?
Very accurate.
Very accurate, you think so? Yeah, okay. Well, let's move on from that just a little bit. How do you feel about a defendant not taking the stand?
I feel unilateral about it, especially if I strongly consider that someone should, but under legal advice and under the advice of a professional, in order not to do so, I would strongly agree with the defendant not to take the stand.
Sure. Okay. So Cassie strongly agrees that maybe the defendant should take the stand if his attorney says not to.
I think everyone has the right to choose, and they could self-incriminate just be out of being nervous and not being in that situation before, they could incriminate themselves mistakenly just because out of nervousness. So I think they have the right not to take the stand just because it's not a comfortable situation.
Well, let me just ask straight out to everyone, does anyone here feel that if the defendant didn't take the stand, he had something to hide? Good.
No.
Okay, so we talked about in a stressful situation how some folks might think they could recall. You were even able to describe the person who stabbed you. But I think at least we agree that in some stressful situations it could be difficult. But what if it was the difference between a 6-foot person and a 6'7" person? Do you think you guys could remember the difference in such a height difference? What if someone described them wearing black clothes, but in fact they were found by the police with a glittery hat and a glittery shirt? You think you'd know the difference between the two, even in a stressful situation? Okay, great. So finally, my client has been charged with second-degree burglary. It's a charge that requires an intent to commit a crime against another person or property. Now, I believe, Megan, you said that if someone had used the doggy door to enter the house, maybe even that's circumstantial, but let's just say they did, you stated that they must be there to commit a crime. Can you think of no other reason why somebody might accidentally be in a house, perhaps?
Well, if they were accidentally in the house, they would probably own the house. Or, not own the house. And they would have to be there for trespassing at least. And I've
So
used
maybe
my
burglary doesn't fit the crime, huh?
Yeah.
Okay. So how about the rest of you? I mean, do the rest of you believe that if somebody is in the house, then it must be a crime that's taking place? Absolutely no other reason why somebody might be in the house.
They'd have to be drunk or drugged up out of their mind.
Right? But even in that case, would you think that they're
confused.
there to commit a crime? You wouldn't
No,
know.
not necessarily. If they were under the influence of something and they were genuinely confused.
Just as I said, I would strongly consider a special situation for a person to walk through a doggy door, but I would not incriminate that person necessarily for a crime. There can be, I can name plenty of reasons why that happened.
Depends on your past.
Hmm?
Depends on the defendant's past. If they have a past crime for doing small burglaries or breaking and entering, then yeah, I'm more likely to go with that they probably did it. But if they have no prior before that, and they have a prior history of being an alcoholic or going to the wrong houses in an accident, then I shift my focus away from that. But if they found him in the house and he was severely intoxicated, I might take another look at why he did it.
So, in closure, there are two very important concepts at play in this case: reasonable doubt and burden of proof. Many of you are criminal justice majors or minors, and I'm sure you understand that beyond reasonable doubt is what the prosecution must prove in order to secure a guilty verdict. This means if you have any reason for doubt, you must vote not guilty. During the trial, I will attempt to show plenty of doubt as it presents the identification of Mr. Williams. It's the burden of the prosecution to prove that a crime has been committed and that the proper crime has been committed. How many of you, if you felt in your heart that Mr. Williams committed this crime, but also felt that the prosecution had failed to show it beyond a reasonable doubt, might still be inclined to find him guilty? Any of you? All right, real quick, just make sure I understand. I'm going to rephrase that question. If the prosecution fails to find or show guilt beyond a reasonable doubt, how many of you will vote not guilty? Let me say that again. It's the flip of the first question. It's the flip of the first question. If the prosecution fails to show guilt beyond reasonable doubt, how many of you will vote not guilty? No? Talk to me about that. Also, you say you would vote not guilty.
Yeah, I would vote not guilty.
Yeah? No,
I'm so confused.
Okay. So, the prosecution does not prove beyond reasonable doubt. Are you going to vote not guilty?
Not necessarily.
Okay. The prosecution has failed to show beyond a reasonable doubt. How are you going to vote?
Depends on what was presented.
Okay.
I strongly believe that due process is not the task of the jury, and I strongly believe that the due process is a task of the defendant and the prosecutor.
Okay. Thank you very much. That's all. Thank you.
Some quick comments. You cannot give the elements to the crime in your voir dire. Those come strictly from the judge.
So where's my elements at?
You're talking about burglary. Also, you cannot tell them what beyond a reasonable doubt is, the definition. Only the judge can do that. So if you'd have done that in court, the other attorney would have jumped up and objected. Right in the middle of your voir dire. John wanted me to, but I said no. I didn't want to break your concentration. Okay, so, Suzanne, who gets to stay and who gets to go? Pick two to go.
So, Erno, I like you, but you gotta go. You believe that somebody can go through a doggy door because he's being chased by somebody? No. I like your optimism, though.
Who else?
Why can't I read my handwriting? So I think it was Megan who said it about less credibility, like if somebody went through a doggy door, someone was traumatized and couldn't recall, it would be less credible. So I would choose her to go as well.
So Megan and Erno go.
Yeah.
Okay, how about you, Kevin?
Mine are easy, and they all came from the last question. So it'd be Cassie and Erno who both tripped over the question, my question, in the way that I wanted to hear it, on burden of proof for the prosecution.
So you wouldn't need to really actually be beyond a reasonable doubt. You just run with your gut feel. Is that it?
Not necessarily. I don't know.
No, the answer is no. It's not necessarily.
So what's funny though, Erno was my man all the way through to the question. Sorry, you're gone now.
Who else?
At least I was unilateral.
Oh,
I was
Cassie.
my vote, so.
Just based on that.
Well, you wouldn't have to waste one on Erno because Suzanne goes first. He would have been gone.
I was unilateral.
The other one would probably be Megan, but I think you squashed her as well, right?
Yeah,
Yep.
And that was just based again, it goes back to the doggy door, which is a heavy part of the case. So.
I would do Kendall as well because you said he recalled all the incidences when he was stabbed. I'm sorry, you were stabbed. So you recalled all of that. I would have to tell him to go through this.
Well, that would be good because our witness
you
didn't
want me to
recall
stay.
the
He would want me to
information.
go, you would want me to stay.
Yes. But you only get a couple of shots, and you got this big crowd, so you got to pick. You have to prioritize who gets to go. I mean, you might have 5 people you want to kick, but you only got 3. So.
It's not a jury selection.